Yo como que todo lo que digas puede ser usado en tu contra. Okay, let me... I'm trying to put my little mic here. Okay, I think it works. Yes, okay, there you go. So I don't mess up with theirs or theirs. And then mine's there. Okay.
Okay, sounds good. Is it questions or they'll be after? They'll be after. Okay. Yeah, after. Great. All right. Can I start? Yeah? Okay, great. Hi, my name is Jennifer Babai. That's Babaie, and I am the Director of Advocacy and Legal Services with the Las Americas Immigrant Advocacy Center based in El Paso, Texas. We are one of the plaintiffs here today, so happy to be with you. Oh, I can make the remarks now? I'm sorry, I thought it was just an intro. Okay, well, hi, y'all. All right, so I'm going to give a plaintiff's perspective just from this hearing today. One thing I'm happy to hear was that I think that this judge understood that the right to asylum is still very much part of our laws, part of our federal laws, and understood that if we were to allow this Texas immigration regime envisioned under SB 4 to go into effect, that we would be impacting communities across Texas. This is very much not just about families and communities on the border. The law is written to apply to everyone. And so what I'm taking out of this is that we are hoping for a win on the preliminary injunction, because that means not one single person will be hurt under SB 4. Thank you.
Okay, so well, good afternoon. My name's Bernardo Cruz. Yeah, good afternoon. My name is Bernardo Cruz. I'm an attorney with El Paso County Attorney's Office, and we're here leaving the courthouse, and we presented our position through papers, and we really hope that the judge joins the enforcement of SB 4. This is a very problematic law that the County of El Paso has expressed its many concerns, and we have demonstrated why the county would be subject to many harms, including to its citizens from expenses that the county may experience, and also through the many initiatives it's trying to do to enforce or make sure that the County of El Paso is a safe place for all persons in the state of the county.
I have a good question. If the bill were to move forward and were to go into effect, does the county have any discretion on whether to use their deputies or their police officers to actually enforce the law?
Yeah, so both the sheriff of El Paso, and different constables are independent elected officials, so they actually have their own priority enforcement. The County of El Paso, through the County Commissioner's Court, is unable to direct any type of law enforcement directed in that instance. Any other questions?
Any response to the state's argument that so what they were saying was a benefit that someone might be put in jail?
Yeah, so we were as an interplay, we were basing off of what the department, the head of the public safety said, and they're envisioning a huge increase in arrests. So we were based off of the primary law enforcement agent in the state of Texas, and we can only base off of those numbers. In El Paso, we've already seen a huge increase in different DPS enforcement actions, primarily through car chases throughout our community. So we can only base ourselves off of that. What we've seen is an increase so far.
Is prison the safest place?
So that is pretty. That was unexpected for them to argue that. The county would say that we try to do our best for all persons who are detained in our facilities, but that was something that I was not expecting.
Do you expect this to go to the Supreme Court?
It seems that the judge, I would agree with the judge that this is a very important issue that is likely to go up to probably to different courts, including the U.S. Supreme Court.
Your name and your title, please?
Bernardo Cruz, from the County Attorney's Office in El Paso County Attorney's Office. Thank you.
Hi, good afternoon. I'll round us out. My name is David Donati, David Donatti, and I'm a senior staff attorney at the American Civil Liberties Union of Texas. What just happened inside of the courtroom is an indication that over 150 years of laws and Supreme Court decisions as well as the very idea of what it means to be a United States, requires a particular outcome, which is that the state of Texas cannot intrude in the field of immigration enforcement, the entry, and more importantly, the deportation of human beings who are here to seek safety. We do not know how the judge is going to rule or on what timeline, but the issues here could not be more important. And so we're very proud to be here with the County of El Paso, with Las Americas and American Gateways.
En español, ¿nos podrías decir
Sí.
tu nombre, David, y tu cargo y qué está?
Sí, cómo no. Mi nombre es David Donati y soy abogado con ACLU de Texas. Lo que vimos ahí adentro es testimonio al hecho de que hay 150 años de leyes que son claras. El área de inmigración es un área que solo el gobierno federal puede regular. No hay ningún espacio para el estado de Texas hacer lo que ha hecho con el SB4 y estamos aquí luchando para que nunca vea la luz del día.
¿Qué esperan ustedes como organización con la resolución del juez? Él dijo que lo haría lo antes posible. ¿Ustedes esperan un fallo que ponga un bloqueo temporal a esta ley?
Ojalá. Nunca se sabe qué va a hacer un juez. Los jueces van a mirar todo, la evidencia, los papeles que entregamos antes de hoy y los argumentos de hoy. Y ojalá él ve lo que nosotros hemos visto, lo que la Suprema Corte dijo hace un año, hace 10 años en el caso de Arizona y muchas veces antes de eso, que esta es una área donde el Estado no tiene ningún derecho ni autoridad a deportar a los seres humanos.
¿Cómo se sienten? ¿Qué confianza tienen? El juez hizo argumentos, cuestionó mucho al Estado durante los argumentos. ¿Se sienten confiados de que pudiera dar un fallo favorable a prohibir esta ley temporal?
Tenemos la confianza, sí. Y no solo es lo que dijo el juez, las preguntas que hizo, que son buenas preguntas, porque el SB4 no tiene ninguna dirección que tiene ningún sentido. La implementación va a ser difícil, sino imposible, porque la ley tiene requisitos que son imposibles coordinar con la ley federal de inmigración. Pero no solo es lo que dijo el juez. Nosotros estamos basando este caso en 150 años de casos de la Suprema Corte del 5 Circuito. Entonces nosotros tenemos toda la confianza y esperanza que la ley, la justicia van a permanecer en este caso.
¿Cuál sería el siguiente paso en caso de que el juez diga, ok, se va a prohibir esta ley? ¿Qué pasaría?
Este es un caso donde esperamos y tenemos confianza que va a subir a la Corte intermediata, el 5 Circuito y la Suprema Corte. Es un caso muy importante que tiene que ver con la autoridad entre el gobierno federal y los estados y también las comunidades fronterizas. Estamos aquí con el Condado del Paso y con organizaciones que trabajan con los migrantes, con las familias y comunidades que todos nosotros vamos a ser impactados por esta ley. Entonces es importante y en un caso como este esperamos que va a subir hasta la Suprema Corte y que ellos también van a hacer lo que es justo y necesario bajo nuestra Constitución. Yes. Sure.
The biggest concern about SB4, at least from a public perspective, has been that it's going to contribute to racial profiling that law enforcement officers would see what appears to be, possibly a document that migrants in private just pulled them over and checked them. But that really wasn't an argument that was made before. Why wasn't that the argument?
It's a really important question, and it's also a very important feature of SB4. And so to be very clear, we have every expectation based on our experience and our history and the work that we do, that this law will lead to racial profiling. And that is because of the simple fact that SB4 criminalizes you not based on what you do, but who you are. So identical conduct taken by a U.S. citizen, for example, those identity-based characterizations that will be carried out by tens of thousands of law enforcement officers across the state of Texas. We have over 2,700 law enforcement agencies in the state of Texas, will lead to racial profiling. And it's not just Latino individuals, it is also Black and Asian American individuals and individuals who are in mixed status families or in communities. All of us will be vulnerable to this kind of identity-based policing, which is a very important part of why this law is unconstitutional and cannot be allowed to stand.
But why not? Why didn't you argue that in court? Like, that was never brought up, the idea of
It came up in one respect, which is on the issue of preemption and supremacy. So you may have caught the judge asking or discussing, well, what about Texas's trespass arrests? And we have a lot to say about Texas's trespass arrests and the way that they are implemented and enforced. And in our analysis, indeed, they do lead to racial profiling and severely racially discriminatory arrest patterns. That is indeed the case. But the important part for this pre-enforcement challenge is, does it intrude on federal immigration regulation? And so as a pre-enforcement challenge, it's important to focus on the text of the law rather than on supposition as to how it will be enforced. And that's why you saw less of that discussion today. But that doesn't mean that it's not going to be an issue with SB4 moving forward. And if there are other parts of the legal system where this law is challenged, and if SB4 goes into effect, we expect that there will be multivariate legal challenges to it. The racially discriminatory elements of it are almost certain to be litigated. I thought that the argument was perhaps poorly phrased. I think the state may regret making that statement, but the statement was to the effect of, there is no place safer for a migrant than inside the walls of a Texas prison. As a matter of fact, that is untrue. In Harris County, where I am from, we have a number of jail deaths every year. The vast majority of Texas prisons and jails are not even air conditioned, and it gets very hot in Texas. And I think that is a statement that none of us would accept for ourselves. As people who believe in human dignity and the fundamental importance of liberty, the idea that we are safe in prison, whether or not that is literally true, which it is not, as a matter of another form of government prosecution, which is the actual deprivation of liberty and incarceration, does not cohere. So that argument cannot stand. It absolutely will hurt asylum seekers. Whether or not the federal government treats these state arrests or removals as dispositive or determinative of an asylum claim as a practical reality, it will completely frustrate the ability of individuals to ask for asylum. And that's one of the reasons that Las Americas and American Gateways are here, because that's the work that they do. But with PASTA's prologue and the Operation Lone Star criminal legal system, people are going to be put in facilities far away from where they are arrested, far away from where they have access to attorneys. And whether or not attorneys do indeed have meaningful access to their clients, the very possibility, which the law guarantees, that people will be removed to Mexico systematically undermines their ability to ask for asylum. Under U.S. law, anyone who is present in the United States, that is physically present in the United States, has the right to petition for asylum. And so the way that the Texas law operates by removing someone from the United States undermines their access to that right. So as a definitional matter, it is an impediment to asylum.
What about the argument?
Senior staff attorney at the ACLU of Texas, and my name is David Donati.
What about the argument about, and this was a little bit of a back and forth, and this argument that an asylum case will not stop the prosecution of this migrant under SB4. Can you explain that a little bit?
This is part of the law itself. So SB4 is very clear that an individual's prosecution for this state law crime will not be abated or stopped on the basis of an individual petitioning the federal government for relief. So, for example, if you come to the United States and you are arrested under SB4, you can, according to the state, petition the federal government for asylum or for withholding of removal under the Convention Against Torture, or a number of other forms of relief which we mentioned. For example, if you're a victim of domestic violence or trafficking and you have testimony that can assist in law enforcement investigations, there are a number of different forms of relief, but they take time. And so what Texas is saying is we want to push people into this criminal proceeding. At the very first opportunity that you go in front of a magistrate judge, you're already put to the choice of, will you go to prison or will you be removed? That's what Texas means when it says consent. Do you consent to removal? And that's day one, or within 48 hours, depending on how quickly Texas moves. Those people could then be removed. But even in a longer case where an individual does choose to stay and defend against prosecution, there is a high likelihood that individuals will not have a determination on their federal immigration claims in time for them to be spared prosecution under SB4. And that is a simple reality of the math of SB4. The state is going to be pushing through prosecutions on the order of months, or at most a year, whereas many of these immigration claims, for example, for asylum, take several years to develop.
Can a state prosecution impact the asylum of someone? I know that if you're seeking for asylum, part of it is like you cannot have a felony. And under the state, under SB4, you could be sentenced to 20 years. Would that impact someone's ability to get asylum?
This is something we have never seen before, so it's impossible to say how it will impact your eligibility for federal immigration relief. With that being said, we would urge the federal government, regardless of administration, to not treat SB4 offenses as crimes involving moral turpitude or aggravated felonies for purposes of immigration law. But again, because this has never happened before, in our entire history as a republic, where you've had a state imposing its own state law crimes, it is impossible to say in advance how this could impact somebody's eligibility to asylum relief. And that is a very important question that these individuals thrust into the Texas criminal legal system are going to have to deal with as they're making these choices. Do I plead guilty? Do I agree to removal? What will that mean for my eligibility to remain here? What will that mean for my safety, for my family's safety? There are so many unknowns that they're going to have to dealing with in a very short period of time in an environment where access to counsel is very difficult. And so this law cannot be allowed to stand.
Thank you.
Yeah, of course.
¿Crees que puedo hacerte?
Sí,
Si
cómo no.
alguien tiene preguntas.
Yo quiero esta parte porque quería y no puedo.
Está bien,
Este
sí.
audio no me sirve.
Yo te quiero hacer también unas preguntas. Estamos en vivo para todo el estado de Texas. Déjame hacer una recapitulación. Y bueno, nos encontramos justamente con uno de los abogados que